Most people never survive this moment legally, and they don't even know it happened. Right now, somewhere in this country, a law-abiding gun owner is sitting at the side of a road with their heart pounding, their hands sweating, and a police officer is about to ask them one question. One single question. And the way they answer it, or the way they don't, will determine whether they drive home tonight or whether they spend the next several months tangled in a legal nightmare that costs them their carry permit, their reputation, and potentially their freedom. That question is this: do you have any weapons on you or in this vehicle? And if you don't have a specific, prepared, legally sound response ready before that officer's knuckles ever reach your window, you are already at a disadvantage. I'm going to give you the exact phrase to say. But first, subscribe to this channel right now, because we publish new videos every week on exactly this kind of information. Your rights. How they work. How to use them. Videos that could protect you the way this one is about to. Go ahead and hit that button. Then stay with me, because this is going to take a few minutes, and those few minutes could be the difference between a minor traffic stop and the worst legal experience of your life. Let's start where almost every one of these situations starts. You are a responsible, law-abiding firearm owner. You have your concealed carry permit. You've done everything right. You trained, you qualified, you went through the background check, you carry legally and responsibly. You are not a criminal. You are not a threat. You are the person the Second Amendment was written for. And you are now being pulled over for something minor, a rolling stop at a corner, a tail light that flickered out without your knowledge. Maybe you drifted slightly over the center line for 2 seconds. The reason doesn't matter. What matters is those red and blue lights are in your mirror now, and everything that happens in the next 4 to 6 minutes will either protect you or expose you to legal consequences that have nothing to do with your actual guilt or innocence. The officer approaches. You roll down your window. You keep your hands visible on the steering wheel, which is exactly right. He asks for your license and registration. You provide them, also exactly right. And then the second question comes. Do you have any weapons on you or in the vehicle? And here is where the vast majority of gun owners make a catastrophic error. Not because they're lying. Not because they're hiding anything. But because they do exactly what their instincts tell them to do. They try to be helpful. They open their mouth and they talk. Listen to how this sounds from the inside. Yes, sir. I have my carry pistol. I have my permit right here, too. It's holstered on my hip. I'm not going to reach for it. I just want to be upfront with you. I was at the range earlier. I'm totally cooperative. I just want to get home safe. That sounds like the response of an honest, reasonable, cooperative person. That's what it feels like when you're saying it. But let me walk you through what just happened from a legal perspective, because what felt like goodwill is actually a series of self-inflicted legal injuries delivered voluntarily, without any warrant, any subpoena, or any legal compulsion whatsoever. Yes, sir. I have my carry pistol. You have now confirmed that a weapon is present. Before those words, the officer had authority to stop you for a traffic infraction. That's it. The moment you confirm a firearm, the legal and practical dynamics of this encounter expand in ways you can't fully control. I have my permit right here, too. Ideal scenario. Your permit is valid, current, and your address on it matches your current address. But what if you moved 6 months ago and haven't updated it? In multiple states, a permit with a stale address is technically non-compliant. You may have just confessed to a violation you didn't even know existed. It's holstered on my hip. You have now told the officer exactly where the weapon is on your body. You have given him precise location information that directly changes how he manages the physical dynamics of everything that follows. I was at the range earlier. You have disclosed your recent activity, which in the mind of an officer building a real-time threat assessment may register as subject was recently firing weapons, is currently carrying, and is in an elevated stress state. You introduce details that were not required, not requested, and not helpful to you. I just want to get home safe. That sentence, sincerely meant, often shows up in police reports as subject expressed concern about the situation escalating, suggesting awareness that the encounter could go in a dangerous direction. You created that narrative. Before you said anything, it didn't exist. This is not hypothetical. This pattern plays out in courtrooms and prosecutors' offices constantly. Defense attorneys have a phrase that every gun owner needs to write somewhere and memorize. You cannot talk your way out of an arrest, but you can absolutely talk your way into one. Here's the core problem, and it is a neurological one as much as a legal one. Under the stress of a police encounter, your brain enters a state where it genuinely believes that talking is protecting you. It tells you that silence equals suspicion, that the more you explain, the clearer things become, that if you just show him you're one of the good ones, he'll understand and let you go. Every single one of those signals your brain is sending is wrong. Silence is not suspicion. Silence is a constitutionally protected right, codified in the Fifth Amendment, that does not diminish because you are a gun owner, does not shrink because the stop was for something minor, and does not disappear because you feel guilty about exercising it. And here is something that genuinely surprises people when they first hear it. Staying silent does not make the encounter more dangerous. It often makes it safer. When you start delivering fragmented, stress-filtered, half-organized information about a firearm in real time, you introduce unpredictability into an encounter that an officer is trying to manage calmly and safely. Fewer words, delivered with composure, actually reduces uncertainty for everyone at that window. But the cultural conditioning runs deep. Innocent people cooperate. Guilty people go quiet. That is one of the most dangerous myths embedded in how Americans understand the legal system. Innocent people are convicted every year precisely because they talked. The criminal justice system is not a character evaluation. It is a procedural framework, and it rewards people who understand how that framework works. Now, the phrase, when a police officer asks you whether you have any weapons, here is exactly what you say. I don't answer questions, officer. 7 words. Calm. Respectful. Legally sound. And before your instinct kicks in and tells you that sounds combative, I need you to hear the specific reasons why this phrase is constructed the way it is, because each element is deliberate. First, it is a statement of personal practice, not a challenge to authority. You are not saying the officer can't ask. You are not saying you refuse to cooperate. You are describing your own behavior in neutral terms, the same way someone might say, I don't drink, or I don't discuss personal finances. It is a personal policy, stated without emotion. That framing matters because it removes the adversarial charge from the moment. Second, it protects you from accidentally committing a crime. If you say no, and you are in fact carrying, you have just provided false information to a law enforcement officer. That is a criminal offense in most jurisdictions. If you say yes and start explaining, you have entered the territory we just walked through. I don't answer questions is neither. You have stated nothing false. You have provided nothing that can be turned against you. Third, the phrasing is general, not specific. It is not, I don't answer that question. It is, I don't answer questions. That single sentence establishes the framework for the entire encounter. You don't have to rebuild it for every follow-up question that comes. You stated your position once, clearly, and it holds. Fourth, it creates physical calm. When you begin describing your firearm, where it is, what state it's in, how many rounds are loaded. You are discussing a deadly weapon, and you are likely moving your hands while you do it. That introduces a level of nervous energy and physical uncertainty into an already heightened encounter. I don't answer questions, officer. Hands still at 10 and 2, body composed, actually signals to the officer that he is dealing with someone who is informed and controlled. Composure communicates safety in a way that nervous over-explanation never does. Now, the words alone are only half the equation. The delivery is the other half. And this is where people take a perfectly constructed phrase and destroy its effect entirely. Wrong delivery looks like this. Eyebrows up, slight edge in the voice, a little exhale of contempt before you say it. Yeah, I don't answer questions. That is a confrontation. That is an invitation for escalation. That is someone daring an officer to push back, and officers are trained to respond to that energy. Right delivery looks exactly like this. Hands at 10 and 2, visible and still. Eyes forward, or calm in natural eye contact, not avoidant, not challenging, just present. Voice flat, neutral, unhurried. Not cold. Not apologetic. The same tone you would use to tell someone the time. I don't answer questions, officer. The word officer at the end is not optional politeness. It signals that you see this as a professional interaction, not a personal standoff. And your physical presentation has to match your words. An experienced officer is reading your hands, your eyes, your breathing, your posture. If your body is broadcasting panic and evasion while your mouth is saying the right phrase, those contradictions will be noticed and will inform what happens next. So your complete physical posture needs to be hands visible at 10 and 2 at all times. If you need to reach for registration, you announce it out loud before you move. My registration is in the glove box. I'm going to reach for it with my right hand. Then you move slowly and deliberately. Breathe. Consciously slow your breathing. It steadies your voice and signals to the officer that you are in control of yourself and comply with every lawful order. If the officer asks you to step out of the vehicle, you step out immediately and calmly, exercising your constitutional rights and complying with lawful directives are not in conflict with each other. They operate simultaneously. Now let's talk about what happens after you say the phrase, because this is where most people fall apart. They manage to get the words right. And then the officer responds, and they weren't prepared for that response, and they cave. Here are the 3 pushbacks you are most likely to encounter, and exactly how to hold your position through each one. The officer says, I'm just asking for everyone's safety. If there's a gun in the car, I need to know so no one gets hurt. That sounds like pure reason. It is designed to. It is pulling directly at your instinct to protect others and to be seen as cooperative. The response? I understand that, officer. My hands are on the wheel, and I'm not reaching for anything. I just don't answer questions. You acknowledged his concern. You demonstrated with your body language that you are not a physical threat, and you held your position without adding anything further. The officer says, if you've got nothing to hide, why won't you just answer? This is one of the most commonly deployed pressure tactics in roadside encounters. The trap it sets is this: if you try to answer it directly, you have re-entered the conversation on his terms. You are now explaining your reasoning, which means you are talking, which means the door is open again. The correct response: that's my personal policy, officer. I don't answer questions. You do not justify it. You do not invoke the Fifth Amendment. You do not explain constitutional theory. You state your position once more and you stop. The officer says, are you refusing to cooperate with my investigation? This is high-pressure framing designed to make you feel like asserting a right is equivalent to committing a crime. It wants you to say, "No, no, I'll cooperate," and start talking. The response, "Officer, I'm complying with all of your lawful orders. I provided my license and registration. My hands are where you can see them. I'm following your instructions. I just don't answer questions." There's a difference between complying and answering questions. When an officer hears that, they know they are dealing with someone who understands the system. In the majority of cases, the pressure tactic stops. Now there is a critical legal nuance that you must understand before you ever get behind the wheel while carrying, and it requires direct attention. What about duty to inform states? Yes, this is real. In certain states, you have a legal obligation to inform a law enforcement officer that you are carrying a concealed firearm when you have an official contact. This is not optional. This is not something you work around. If you are in a duty to inform state and you are carrying, you disclose. But here is what most gun owners do not understand about how narrow these laws actually are. They specify what you must disclose. They do not obligate you to answer every follow-up question that follows from that disclosure. The duty to inform is not a blanket waiver of your Fifth Amendment rights for the remainder of the encounter. Here's how you handle it correctly. As the officer approaches, have your driver's license, registration, and carry permit ready together. When you hand them over, you say, "Good evening, officer. I'm legally required to inform you that I have a valid concealed carry permit and I am currently armed. How would you like to proceed?" Then you stop talking. Hands back at 10 and 2. You satisfied the legal duty completely. You presented your permit. You disclosed your status. And then you ended with a question that returns the operational direction of the encounter back to the officer. You did not say where the firearm is. You did not describe its condition. You did not explain when you last used it. When follow-up questions come, where is it? Is there one in the chamber? How many rounds? That is when you return to your phrase. "I've complied with my legal duty to inform you, officer. I don't answer further questions." You have done everything the law requires. The duty to inform statute does not transform you into a compelled witness against yourself for the rest of the stop. And then, there is the search question. "Can I search your vehicle?" This question is designed to feel like it has no clean exit. If you say yes, you have waived your Fourth Amendment rights and whatever they find is in play. If you say no, you feel like you're confirming guilt. You're not. You're exercising a constitutional right. And here is the legally precise, non-confrontational way to do it. "I do not consent to searches, officer." Not. "You can't search." Not. "I know my rights." That phrase almost always inflames rather than de-escalates. "I do not consent to searches" is a calm, legally operative statement. If the officer continues pressuring, "It'll go faster if you just let me look, if you have nothing to hide," the response never varies. "I understand. I do not consent to searches." You are not arguing. You are not escalating. You are exercising a right that exists independent of how the officer feels about you exercising it. Now, if the officer proceeds with a search anyway, you do not physically resist. Ever. Physical resistance is a criminal offense, it endangers you, and it gives a prosecutor something far easier to work with than whatever they were originally looking for. What you do instead is sit completely still, state clearly, "I do not consent to this search," and let them proceed. You observe everything. The time. The officer's name and badge number. What they touched. What they said. What they found or didn't find. And the moment the encounter ends, you document every detail before memory degrades. Because your clearly stated refusal is not for that officer in that moment. He is going to do what he decides to do. Your refusal is for the judge. An unlawful search conducted without consent or probable cause is a Fourth Amendment violation. Your attorney can file a motion to suppress whatever was found. Evidence obtained in violation of your constitutional rights can be excluded from trial, but only if you preserve those rights by clearly refusing consent and not physically resisting. You cannot preserve rights you gave away voluntarily. Now I want to address the thing that may be sitting with you as you've been watching this, because I know it comes up. You're thinking, I'm innocent. I have nothing to hide. I don't want to act like someone who's hiding something. I hear that completely. That comes from genuine integrity. But here's what the system teaches over and over again. It is not designed to reward your integrity. It is designed to process information. And every piece of information you volunteer enters a system that has no obligation to interpret it generously. Prosecutors don't give credit for transparency. They look at what was said and ask how it can be used. Defense attorneys look at what was said and ask how to limit the damage. The less there is to limit, the better the outcome for you. And consider this. Research from the Innocence Project shows that in a significant number of wrongful conviction cases later overturned by DNA evidence, the innocent person had made some form of incriminating statement to law enforcement. Not because they lied, because they talked. Stress produces imprecise, inconsistent, sometimes contradictory statements. And imprecision, inconsistency, and contradiction are exactly what a skilled prosecutor builds narratives from. Staying silent is not a betrayal of your honesty. It is the intelligent exercise of a right that the founders embedded in the highest law of this nation because they understood, from lived experience with abusive power, what happens when people are pressured to speak. And now the scenario you need to be prepared for even if you do everything right. Because sometimes you do everything right, and you still hear those words. Turn around. Hands behind your back. You are under arrest. Your entire system is going to tell you to fight this. To explain yourself. To make him understand right now. Do not do it. When those words are spoken, you have two jobs and only two jobs. Job 1. Comply physically. Hands behind your back. No resistance, no pulling away, no argument. The safer the officer feels during the physical process of arrest, the less likely this becomes something far more dangerous. This is not surrender. It is the smartest possible strategy in that moment. Job 2. Go completely silent. In the back of the cruiser. Why did you have that gun? Nothing. You're in serious trouble here. Nothing. If you just explain yourself, we can maybe work this out. Nothing. That last one is the most seductive because it sounds like a way out. It is not a way out. It is a recording device pointed at your future. Once you are in custody, anything you say is evidence. The officer is not there to help you build your defense. He is there to build the case. There is exactly one phrase you say after an arrest, and you say it clearly and completely. I want my lawyer. Not. I want my lawyer because. Not. I'll tell you everything once I've spoken to someone. Just those 4 words, stated unambiguously. Because once you invoke your right to counsel, questioning must stop. If it continues after that invocation, what you say may be inadmissible. But you have to actually say it. Silence alone is legally insufficient at this stage. You must invoke the right to counsel explicitly and specifically. And once the encounter is over, whether it ends with a warning, a ticket, a search, or an arrest, you write everything down immediately. Every word that was said. What time it was. Where you were. The officer's name and badge number if you saw it. What was searched, what was found, what wasn't found. What you said. What they said. Research consistently shows that detailed memory of a stressful encounter degrades rapidly within the first 30 minutes after it ends. Capture what happened while it is still accurate. That documentation is not paranoia. It is evidence. It is the foundation your attorney will need if anything about that encounter requires challenge later. And then, you call an attorney before you have any further conversation with law enforcement about the incident. Not because you did something wrong. Because you deserve someone in your corner who understands how the system works. Here is the complete framework. Before any drive, know whether your state has a duty to inform law. Know exactly what it requires you to say. Have your carry permit in a known, accessible location and make sure it is current. The moment to verify this is not when there are blue lights in your rearview mirror. During any stop, hands at 10 and 2, visible at all times. Announce any movement before you make it. Breathing steady, tone neutral, body calm. In a non-duty to inform state, when the weapons question comes, I don't answer questions, officer. 7 words. Deliver them calmly, hold them without adding anything further. In a duty to inform state, officer, I'm legally required to inform you that I have a valid carry permit and I am currently armed. How would you like to proceed? Then stop. For all follow-up questions, I've complied with my legal duty to inform you, officer. I don't answer further questions. When a search is requested, I do not consent to searches. Hold that regardless of pressure. If they search anyway, do not physically resist, state your non-consent clearly, document everything after. If you're arrested, comply physically, say nothing, invoke counsel immediately and specifically. I want my lawyer. That phrase, I don't answer questions, officer, is not a trick. It is not a loophole. It is not evasion. It is a statement of identity. It is you announcing, with composure and dignity, that you understand what country you live in, what that country promises its citizens, and that you intend to hold the system to that promise. It protects you from self-incrimination. It protects you from misquotation. It protects you from the nightmare of trying to be helpful and accidentally building the evidence that gets used against you. And it protects the physical safety of the encounter itself, because an officer at a window with a calm, composed, legally informed person in front of them is in a fundamentally different situation than one trying to parse a stream of nervous, contradictory, volunteered information about a loaded firearm. You earned your carry rights legally and responsibly. You carry legally and responsibly. Know your state's laws. Know exactly what they require of you, and meet those requirements precisely. No more and no less. And when a question comes that goes beyond what the law requires you to answer, you know exactly what to say. Hands visible. Tone respectful. Words minimal. Those 3 principles, applied consistently, are the most reliable legal protection you have at every police encounter you will ever face. This content is for educational and informational purposes only. It is not legal advice and does not create an attorney-client relationship. Laws regarding firearms, concealed carry, duty to inform, and police encounters vary significantly by state and jurisdiction, and they change. Consult with a qualified criminal defense attorney in your specific state to understand the exact laws that apply to your situation before you need that information. If this video helped you understand your rights a little more clearly, subscribe to this channel right now. We publish content specifically designed to help you understand your rights and how to use them, so that when the moment arrives, you are not learning on the fly. Hit that subscribe button and turn on notifications so you don't miss what comes next.